one of the key components of any case is it's got to be a really significant injury. One of the biggest mistakes I think that med mal lawyers make is choosing, kind of having the initial look at a case be based on the perceived strength or weakness of liability. I try not to do that. I don't want to take a case that I think has slam dunk liability, but maybe has questionable damages. Because how many times do you take one of those cases and you get into it and you realize, well, maybe liability is not as strong as it was. So it's always, always, always the first criteria is there really a significant injury here? And part of that is a business decision, but part of it, quite honestly, is we've got a finite amount of time, we've got a finite amount of resources, and my team and I really want to dedicate those resources to helping the people who we truly feel need our help the most. And so that's the initial criteria. And then we look at liability, of course. I got to see a path to liability. I don't have to be convinced that I'm going to be able to make liability on a case before we agree to take it on, because obviously there's a lot more research and investigation that needs to be done on that piece of the case. But I got to be able to see a path. And then the third criteria for us, and I alluded to this before, it's got to be people who I feel like we will want to work with for years.